All right, the court calls case number 21-65425. That case involves Jefferson Capital Systems LLC versus Ebony White. The court is also calling the suffix 9505. That case is Jefferson Capital Systems versus Glenn Harrison. The court is also at this time calling the suffix 2962. That case involves Jefferson Capital Systems LLC versus Hazel Corbin. The matters are before the court for final pretrial conference hearings in each of these matters. Counsel, your appearance for the plaintiff regarding these matters, please.
Yes, Your Honor. Thank you. Terry, Terri, Gruca, Gruca, P55821 for plaintiffs in all three of those matters.
All right, and thank you, Ms. Luca, and good morning to you. So this is my first look at these matters post the transfer from another docket to this docket. I know that the Honorable Judge Brew was handling these matters. I do see in the initial file that I called the Ebony White file, looks like in that matter, that's the suffix 5425. Does not look like there are any motions pending, but that this has come to the end of a period that was previously scheduled. Is that correct, counsel?
It is, Your Honor. This is a case where no answer was filed. It's actually just a transfer from the 17th District Court based upon a new address being found. She has been served properly, and unless Your Honor has an answer there in his file, there's been no answer filed. It's just a matter of the 36th District schedules these for motion since it's a transfer from another court.
All right. Yeah, I do not see any notation of an answer being filed in this matter. And on that basis, I would, just one moment. And I do see that the court set up a scheduling order and then established today's date as the final pretrial conference. So in as much, do I have Ms. White here? Ebony White is who I'm looking for. If you're on this Zoom, please say something at this time. The matter was set on for 9:30 a.m. this morning. The defendant has not appeared. The defendant has otherwise responded to the complaint in this matter. And I believe you have a petition for entry of judgment by default at this time. Is that correct, counsel?
I would, yes, Your Honor.
All right, the court will grant the petition for entry of default and will sign an order consistent therewith. Based on the terms as set forth in the complaint. All right, and do you have an email address to send you a judgment here?
I do not, Your Honor. If you could provide that.
Yeah, so that's Latifah, LATIFAH.Hunter @36districtcourt.org.
Is district court all spelled out, Your Honor?
Yeah, 368 district.org.
Okay, thank you.
All right, and now the court is addressing the suffix 9504. This matter is set on for a final pretrial conference as well. I do see where a scheduling order was established in that matter. I also see that there is a document in the court's file wherein Glenn Harrison indicated I would like to see proof of the beginning activity of the web bank Fingerhut account and activity leading to the end of the final account of the Fingerhut account. Do I have on, I know that counsel has entered her appearance, do I have Glenn Harrison on this Zoom? Glenn Harrison. All right, Madam Counsel, I don't believe, other than the document that I just made reference to, I don't believe I see any other formulation of a purported answer. Do you have an answer?
Your Honor, we didn't even have what you referenced in your file. We simply received the order from the court with referencing an answer, but didn't have anything attached to it. So what you just read to me is the extent of what I know from the defendant's perspective.
All right, very well. It appears then that the defendant has not appeared for this duly noticed hearing set on for 9:30 a.m. I do not see an answer in form, although this document says my name is Glenn Hourston and I am providing my written answer for this summons. It is not in the form as required by the order of the court, strike that by the court rules. However, if the defendant was here, the court would make further inquiry on this date. Given that that is not the case, the defendant has not appeared to plead regarding this matter. The court will now determine that the defendant is in default. And I suppose that you are requesting that the judgment be entered accordingly. Is that correct, counsel?
That is correct, Your Honor.
I do see in this file a default application and requesting default judgment in a total amount of $1,237.39. That was received by the court on January 4th. Would you like for the court to enter that judgment, or would you be sending in a different one?
Your Honor, I do believe that passed in the mail with the court order, and that is still the current balance. I would request that Your Honor go ahead and sign that and enter that as of today.
All right, the court will sign the judgment as indicated, finding that the defendant is in default, and the order is assigned accordingly.
Your Honor, can I go back real quick to the email address you provided in the previous case?
Yes, ma'am. Go right ahead.
Latifa.hunter@36districtcourt. What?
Org.
.org. Okay. Thank you.
All right, thank you, Madam Counsel. And let me take a look at, it is now 10 o'clock a.m. Do I have on this Zoom Hazel Corbin, or anybody connected to Hazel Corbin on this Zoom at this time? All right, this is in regard to the suffix 2962. It is duly scheduled for 10 o'clock a.m. It is set on as a final pretrial conference. The court did issue, under the authority of Judge Demetria Brew, a pretrial scheduling order setting today's date as a date for final pretrial conference and for motion hearings. I do see a document, a handwritten document that looks like it purports to be the answer in this matter. The defendant is required to be here on today's date. Madam Counsel, your position regarding this matter?
Your Honor, we have spoken to Hazel Corbin and actually came to an agreement regarding payments. We have not received the agreed upon resolution paperwork back. That was back in February, though, and we've had no contact with anyone on her behalf or her herself, based upon what you just referenced and the fact that she was duly advised to appear in court today. We would simply request that my office be allowed to send in a judgment for default based upon her failure to appear in court this morning.
All right, the court will find that the defendant is in fact in default and will enter a judgment as prayed in this matter. I do have a judgment form that was received by this court December the 30th, 2020. It's a total judgment amount of $3,190.35. It does not have a provision for monthly payments. I could stand down on this and wait for a judgment with an agreed upon monthly payment amount, or given that the defendant is not here, the court could could simply enter the judgment at this time.
Your Honor, my only concern in you waiting is that we've been trying to obtain that signed consent judgment from Ms. Corbin since February. So at this point, we would still honor the payment plan if she contacted my office, but at this point, we would request that the judgment be entered. And if she advises us she wants to start making payments, she always can.
All right, the court will enter the judgment. I'm noticing here with the answer that was filed, that it was, the main thing that was mentioned in the answer was a significant inability to pay, secondary to defendant being on some form of pension and or disability, social security pension. Was there an agreed upon amount based upon if she entered into the consent, what she would pay per month?
We had agreed, again, previously back in February to monthly payments of $75 a month starting March 10th.
All right. All right, yeah, that's pretty much what she's asking for in her answer. So I'll go ahead and sign the judgment. I was a bit tempted to put that language into the judgment document. But you've indicated on this record that your office is open to abide by those terms as informally agreed upon to the extent that she engages in such payments, correct, counsel?
Correct.
All right. All right, very well. The order is entered as set. Thank you, counsel. Before you leave, sir, your name for the record? You're on mute. If you could unmute yourself so I can hear you.
Glenn Harrison.
Oh, Mr. Harrison, I already called your case. Let me go back to it for a moment here. And with regard to this matter, the court a few minutes ago entered a judgment by default regarding this case because you weren't here when you were supposed to be here. So what's going on regarding this matter? There's a claim that there is $1,237.39. That is the balance in this matter, sir.
Okay. First, Your Honor, I would like to say I had the incorrect meeting ID, and I just called the court clerk, and she gave me the correct meeting ID.
Got it, sir. All right. So this has been going on for a while. The case has been here since 2020, and I'm the new judge on this because the other judge, as you probably noticed, was sent to the landlord-tenant division where I used to be. So this is the final pretrial conference, and usually, well, oftentimes people come up with a way to get the case resolved at this stage in the proceedings. They're basically saying that when everything is considered, that the balance on the account that was existing at this time is $1,237.39. So, Mr. Harrison, what do you have to say about that, if anything, at this time, sir?
Well, I was focused on trying to take care of my bills. You know, we had the pandemic in 2020. I've been a temporary worker. I could never hold a stable job. Everybody, you know, temps, they want to have you working for like maybe 2 weeks and lay you off. So I've been going through that type of stuff. Jefferson Capital reached out to me maybe last week for a settlement offer. And I didn't make any promises because I don't have any stable employment yet. I'm working right now, you know, but I'm still a temporary worker. So I'm not gonna make any promises for a payment plan. Then I default on it, and then I'd be in bigger trouble. So I'm just trying to wait till if I get hired. Then my 90 days is coming up, in maybe about 2 or 3 weeks. If I get hired in, then I can make a promise and have something I take care of.
So you're not disputing at this time that the debt is what it is, correct?
Well, yes, I do also want to see proof of the claim.
All right. So they sent you a complaint in this matter. You got the complaint telling you how much was owed and so on and so forth, correct?
Yes.
How much do you believe that you indicate that you seem to indicate that you know that there's some obligation here? How much do you think you owe on this?
Well, I would like to take a step further than think. I believe maybe a few years ago, my balance was at $1,800. They claimed $1,800 was the total.
All right. Well, you recognize the amount they're claiming now as your total is, and this is with certain court costs. So your total would be $1,237.39. So it wouldn't be any more than that. Here's what I'm getting at is that at this point, if there's not a real dispute about the amount, then the court would go ahead and enter the judgment, and you can always reach out to try and reach a payment plan. And if you weren't able to get an agreement, you could file a petition with the court for partial payments. That would give you an opportunity to pay on a partial basis as well. Sometimes it's good at the beginning if you can reach a payment amount, even if the initiation date is set for some date in the future, because it gives you some certainty as to what you have to do, and that will prevent things like wage garnishments and so on and so forth. So, for example, if the judgment was entered and you came to agreement with the other side regarding what partial payments would look like, then you pick a date, say 30 days down, where you make your first payment, and then another payment be due every 30 days after that. That way, you kind of solve it all at one time in terms of being able to know what can happen, and it's not something that's hanging out there. You don't know what's going to happen next. That's all I'm saying. I understand what you were talking about is about not wanting to get to make a commitment that you felt like you couldn't keep. But if you owe a certain amount of money and you settle that part of it, then it might be wise to say, well, if you give me 30 days, I can make that first payment. And then 30 days after that, the next payment, whatever that amount is, the parties could agree on. That way you don't have to be running back and forth to court. You don't have to worry about getting your wages garnished, that kind of thing. That's what I'm getting at. Right. So if you want to think about that for just a moment, here's what I'd like to do.
Your Honor?
Yes.
I'm sorry to interrupt you, but just to kind of build on what you just said, Mr. Harrison did speak to my office on the 12th. We did offer him payments as low as $50 a month, and we would be agreeable to push that out, first due date, maybe June 15th. That's, almost a full month from now, which would not only give him time to maybe get more security in his job, but as well, as you said, protect his wages going forward. So I just wanted to throw that out there to confirm again to Mr. Harrison that the conversation he had with us on the 12th, the $50 a month is still out there as an offer.
And I'll just chime in there. I mean, if there's not a dispute regarding there being some money owed, if you can have an opportunity to pay it at $50 a month, and you don't have to do that first payment for 30 days, I'm not trying to say what your resources are, but that's a way for you to kind of control this and not have to worry about getting your wages garnished. That sounds like a really good way of doing it. So I don't want to force your hand, but I think that makes sense. You want to do that, Mr. Harrison?
Yes, I will accept that offer.
All right. All right, so, and it makes sense to me. I'll set the default judgment aside. I'm going to enter the judgment as a consent, the same amount number that I told you previously. The judgment will be payable in monthly installments of $50. The first installment payment would be I'll set it on a Friday. That's going to be June the 18th. That'll be the first $50. And then every month thereafter on that Friday, that's like the third Friday of the month. Would be when you would pay the additional $50 towards the judgment. And obviously you get in a better position. You can always pay more. That way you get it over faster, but that would be the amount that you would be obligated to pay to keep it from resulting in a wage garnishment type situation. You understand, sir?
Yes, sir.
That makes sense to you, counsel?
It does, Your Honor. If I can just say to Mr. Harrison, if you want to set up some sort of recurring payment with my office, just call us before the 18th. And someone here can talk you through how to set that up, okay?
Okay.
Like an automatic debit type of thing, okay? All right, so Madam Counsel, you can email the order to me. I'll sign it as a consent, and then I'll get it back to you, and Mr. Harrison will get a copy as well, and that will be the resolution in this case. All right, I wish you well, sir. Glad you made it in before we finish things out, and wish you well on the continued employment. These have been some tough times, so I wish you the best, sir.
Thank you.
Thank you, Madam Counsel.
Thank you, Your Honor. Have a good day.
Good day to you. And thank you for your patience, counsel. I'm coming right to you, sir.
Thank you, Judge.
All right, this is case number 19-174-036. This is Chief Financial Credit Union versus Mark Gistinall Jr. The matter is before the court on an adjourned date of hearing. On yesterday's date, the court called the matter, and no one appeared in the hearing at that time on the initial call. It was discovered later that counsel for the plaintiff had been redirected by some information that everybody's getting redirected by that led him to a courtroom other than this courtroom. That is my previous courtroom. He came in later on yesterday, and I did not have a court reporter at that time, so I asked that he would return so the court may make a record on today's date. Your appearance at this time, counsel.
Good morning, Your Honor. Andrew Johnston, P79752, on behalf of the plaintiff.
Thank you, Mr. Johnson. Mr. Johnson, I have not heard from the other side in this matter, Mr. Gistinall, either yesterday or on today's date. There's been no indication of any effort to reach the court or make any contact with the court. This was set up as a hearing by Judge Brew, my predecessor in this matter, on the plaintiff's motion to set aside dismissal and reinstate the case to be heard yesterday at 11 a.m. Again, the defendant did not appear at that time. You may proceed at this time regarding the motion in this matter, sir.
Thank you, Judge. This is plaintiff's motion to set aside dismissal and enter a default judgment pursuant to Michigan Court Rule 2.502C. Your Honor, this case was originally filed in late 2019. We filed our default, or actually our default judgment. I'm sorry, I'm jumping ahead, Your Honor. The defendant was served in January 2020. We filed our default requesting judgment in March 2020. Certainly, as Your Honor is aware, the court slowed down or potentially stopped operations for a while during the early parts of the COVID-19 pandemic. So we, the court finally rejected our default judgment in July 2020. However, Your Honor, we didn't receive any notice of that rejection. The court finally sent a notice of intent to dismiss, which was dated February 11th, 2021, and we received it on February 22nd, 2021. However, according to the court's register of actions, the case was dismissed February 19th, which was 8 days after the notice of intent to dismiss was issued. Under the court rules, plaintiff should have had at least 21 or 28 days to respond to that. So because the case was dismissed,
if you will, at this point, and I'm sorry, Mr. Johnson, as it relates to that prong of your request, I will set aside the dismissal and reinstate the case. It's obvious to this court that given the various COVID protocols and the emergency restrictions that were placed upon the court, that the notifications regarding intent to dismiss was not served with enough notice. We were also dealing at that time with significant mail-related issues, and that clearly would not have given the breadth of opportunity to react to the notice of intent to dismiss. And that notice of intent to dismiss was really based upon the notion of no progress, and that lack of progress was, that lack of progress was occasioned by the fact that there was not any notification regarding the rejection of the proposed judgment by default. So the court finds that there is a solid basis under MCR 2.502C to reinstate the matter at this time, and will order the same.
Thank you, Judge. May I submit a default judgment to the court? Proposed default judgment?
Yes, you may. I think that my predecessor had some difficulty with the claim and delivery default. What was it in this? I don't see it in front of me. Well, let me look a little bit. But tell me about that. Well, I'm looking here at the proposed order. Just one moment, sir.
Sure.
All right. Well, I won't touch that part of it now. I see that I see your proposed order, a reinstatement, further order that a claim and delivery default judgment shall be entered for plaintiff against defendant without further court hearing. So I'll sign that order at this time.
Thank you, Judge.
Appropriate outcome at this point. You may at this time, sir. Anything further?
Thank you, Judge. And is it at all possible to email or fax a proposed judgment to the court, or should that come by mail?
All right. So the document that you have, I have that you presented. You're talking about a subsequent order.
I'm sorry. I see the
Okay.
order
Here's what I'm
that.
getting at. Yeah, I'm getting at the order that you submitted with the motion. All right. Now, I know that you have another order that was rejected by the judge, Judge Bruce. She says order that claim and delivery complaint is deficient as failing to comply with MCR 3.1 to wit 3.105. Filing a motion for possession pending judgment. Furthermore, failure to cure within 20 days. So what's going on there?
Yeah, I'd be happy to address that, Your Honor. I see that in the Register of Actions. Judge Brew references failure to comply with 3.105, filing a motion for possession pending final judgment. Your Honor, that section of MCR 3.105 is it's permissive. It states that plaintiff may file a motion for possession pending final judgment, and the purpose is basically to prevent the defendant or the party in control of the collateral or whatever the claim, the subject of the claim and delivery is, from damaging it or hiding it or anything like that. But in this instance, defendant didn't even respond to the original complaint. So, as far as filing a motion for possession pending final judgment, that really doesn't serve any purpose for my client. Certainly they didn't respond to the initial complaint. They're not going to respond to a subsequent order not to do anything to the collateral. So again, Your Honor, that section of 3.105, it's permissive. It says you may file a motion for possession pending final judgment. It doesn't say plaintiff must file that motion.
All right. Well, I've signed your order. If you have a subsequent order that you got to send in, we'll spell this order out to you. The order in response to your motion.
I was just.
Go ahead and listen to you.
I'm sorry, Judge. I was just talking about the actual judgment. And I apologize for this, I don't believe we submitted a proposed judgment with our motion to set aside and reinstate the case.
That is correct.
Perfect. Thank you very much, Your Honor.
All right. Thank you, Counsel. Good day to you, sir.
You as well.
As a matter of fact, it does have it here. It's already here.
Oh.
So. This is the stuff. Deborah, what's going on there?
Slow motion. A little sleepy today for some reason.
You better speed yourself up. You know what they call it? Shape up or ship out.
I'm trying. That attorney, he was just going around in circles, huh?
Are you talking about the guy just now?
Uh-huh.
No.
Oh.
I understood his arguments.
Mm, mm, mm. So Mr. Sagadi coming in here at 11 o'clock?
Yeah, I think I saw something.
There must be something left over.
with you?
Yeah.
Yeah, something here.
Hi.
Yeah, you can get tired.
I know. Yeah.
Never can be tired.
Deborah can be tired.
Never can be tired.
Deborah tired now. She said she got to come in here next week.
Yeah,
Tired.
yeah, she's gonna really be tired.
Wore out.
We've been to change your life.
Wore out. Gotta get up, get down there.
Yeah. Now, you in the New Center area, right?
Oh,
You.
no, I'm like in the Mexican village area.
What you say?
I'm like in the Mexican village area.
Oh, okay. All right. Well, point is, you just up the street.
Oh, yeah.
Come on.
Yeah, but I gotta get up earlier. Before I was getting up at 7 o'clock.
Oh, yeah.
Now I'm gonna have to get up at 5:30.
Wow, what a penalty. Let's
5:30.
be here. I don't know what you're doing.
That's it.
I don't know how they're gonna let us all in at the same time. This is what I'm worried about.
Latifah, you near downtown or?
Oh, no, I want to west side over here.
See, she way over there.
People got a lot of energy.
No, I don't.
Yes, you do.
I love.
Yes, you do.
We need you that. We need you that. I agree with her on that. Even if you,
I want what she have. What you do to make you have so much energy with people?
Nothing, I guess. I don't have no energy. I be tired too.
it's called not having a choice.
Yeah, I'm about to say, yeah. I don't know, Deborah. I'm like, I don't know.
Oh. I'll get in the swing of it. It's just gonna take me a minute.
Yeah, you got to get it back into it.
Right.
It probably won't take you long neither.
I don't think so. But just,
It just probably might get a little boring and you'll be like, dang.
My wife is showing he and all.
I know
What
she
what she say, Judge? What you say?
I say my wife is he and all.
Your wife is what? One more time.
She's making a noise about it.
Oh,
I mean, she never had a problem getting up. She just the idea of the kids. But we kind of got it worked out. So we got somebody, because they're schooling at home.
uh-huh.
That makes it a little interesting because she was able to work and they have their desk right there on both sides. She was
Oh,
able to
yeah.
be home teacher and work right along with the school.
Uh-huh.
Now we gotta have somebody else there because I think Ethan's 10, so he can handle it. But man, you give Ace that much freedom. I'm gonna have to wear his bottom out.
Yeah, leave Asa alone. Asa is just a free spirit.
Yeah, he's a free spirit. Ain't no question about it. But he got to be free spirit at the right time.
Asa say, no, not right now, Dad. I don't want to right now. Not right now.
But he's so delightful, But he will totally distract.
Well, did they say when the kids go back to school?
Well, I'm sure that they're going to be fully open for the fall. In fact, we're likely changing. I think I'm just going to send them where I sent my other boys to the academy out there. They were open all year anyway. Should have sent last year.
It's gonna be an adjustment for all of us. Woo. Wow.
Huh?
Said it's gonna be an adjustment for all of us. I mean, it's not like we was out 6 weeks. We was out over a year.
Yeah, I know.
Yeah, that's gonna be a big thing.
Yeah,
People that haven't been here.
Y'all been feeling like
Right.
y'all was retired and still getting paid. Now you gotta come back and work for that pay.
And that's gonna be a big old difference now.
That's gonna be a big difference. I'll might be a little irritable. I might be a little slow.
Yeah, we won't pay you no mind then.
Thank you. Thank you.
Latifah here laughing at you. I want you to know that. Like,
I'm glad Tifa here because
she's like, I've been here. I've been here doing my job, so I ain't got no problem. Y'all come on in here.
Tifa is understanding. Some people are not.
Who understands?
Some people are not.
Latifah said, Latifah understands, but she telling you to get your butt in here and come to work.
I don't know why y'all think we don't work because we not there.
I know you working. You know I know that.
Yeah. We'll work.
It just feels good to be at your own house though. It feels good to be able to, you want to get up or whatever, and then when you're done, you can just get home at your own ease, you know.
Yeah, you
On
know,
time, leisure.
That's look. That's the only good thing about it. No. Yeah, it is. I won't lie. You know, especially this past winter, we didn't have to come in and all that.
Right, that was that had to be special.
Yeah.
But look at it like this. I've been working longer than both of y'all. So how about
Well, how you figure
that?
Where you got that from?
I've been working since I was 16.
I've been working since I was 11.
But who the oldest? I
I don't know, but I know it's not no 5 year difference.
No.
Just comes with it.
I've been working. I was working before 16. What am I talking about? It's gonna be good and hot.
The problem for some of us is that you get to the point where you don't know how to quit.
Okay. It was for today.
I know that won't be me.
Yeah.
Yeah, so you can zoom in here. I'll give you the meeting ID number 360.
How do they have the heat in there? Is the temperature right, Judge, or is it too hot or too cold?
It feels pretty good to me.
Oh, okay.
I like where it is.
40. Okay.
You know, they got the air on.
Oh, okay.
Yes.
Really got the air on now. You know how they can be with that air sometimes. Be in the
Yeah,
summer.
that's what I know. It'd be freezing in the summer and burning up in the however it go.
So yeah, I think they got that right.
But you really need to know about that.
So I don't know what the plan is for people, coming in to file their, coming to court.
Yeah.
I haven't heard anything about that, so I think we'll still be doing Zoom.
That's good. Are y'all gonna have a meeting